This Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge Davis, we welcome counsel to this oral argument, which we are live streaming to keep our courts open for the public's viewing. We will conduct the hearing in the same manner as if we were all in the courtroom together. Each of you has 15 minutes, and the appellant has reserved some of that for rebuttal. Unless you have any announcements, I'll ask Mr. Hibner to call the case.
HCTEC Partners, LLC versus James Prescott Crawford et al.
All right. Ms. Berg, you have the floor.
Thank you so much, Your Honor. May it please the court. My name is Erica Berg, and I'm honored to be before you representing Mr. Crawford and Result Group, Inc., defendants below. I focused the first part of my argument on 2 points relating to the recovery of attorney's fees in this case, and I'll reserve other points, and particularly on the summary judgment issues, for rebuttal. The Chancellor made 2 holdings that we think have significant policy implications for Tennessee's workforce. First, it held that contractual prevailing party attorney's fees are compensatory damages that can be trebled under TCA 47-50-109. Resting its decision on a single federal court opinion. The Chancellor granted HCTEC, which is how we talk about it, a temporary and then permanent injunction preventing Mr. Crawford from working with Result in the capacity for which he was hired for a year from the date of the first order. Although Mr. Crawford was not allowed to take the position for which he was hired until the expiration of the injunction, he did work for Result the entire time. And as HCTEC admits, Crawford's working with Result caused HCTEC no damages, no consequential damages, no actual damages, not even nominal damages.
That's probably because they got an injunction against him, prohibiting him from doing the things that he would have done but for the injunction.
And that is the argument that they made, but that this goes to the point that we're talking about what you can treble then under 47-50-109. The Chancellor gave HCTEC the right to recover prevailing party attorney's fees for that injunction, and then trebled those fees against Result. He reserved the issue of the amount of the attorney's fees for a jury trial, categorizing them as damages. But allowing prevailing party attorney's fees creates reverse incentive to litigate. It gives employers the idea that they can go out there and potentially gamble and win. Second, the Chancellor held that Anna's 47-50-109 case for statutory inducement for a breach of contract, a plaintiff can prove the elements of intent and malice merely by showing that the new employer offered the new employee a job with knowledge that there was a purported non-compete agreement, creating strict liability. It requires a new employer to believe that all non-compete agreements are enforceable, relieving the former employer of its burden to show the enforceability of the non-compete agreement. It turns the question of malice then in the statute from willful violation of a known right to willful violation of an alleged right.
In this particular case, though, Ms. Berg, your client was not, as I understand the facts, was not concerned with the content of the non-compete at all, and hired him without knowing that there was a non-compete, but not having asked for or been provided with a copy of the terms of that non-compete.
The question then is, what was he supposed to be doing? And that goes into the record quite a bit as to whether he was a producer or a non-producer. And in this situation, Mr. Crawford was not being hired into a role where he was going to be interacting with customers or in any kind of facing way where he could actively compete against HCTEC. And so that was the position that the client took, and that was the position that they put forward before the court. When we're talking about these particular things, when we're talking about the trebled attorney's fees in particular, we submit that it's counter to this court's long-standing views that covenants not to compete are disfavored because they're in restraint of trade, and attorney's fees can only be recovered in specific actions. The trial court trebled the attorney's fees under the independent tort exception to the American rule, which normally prevents parties from getting attorney's fees in litigation. I've not seen another case where this has been applied in a tortious interference case. In each of the Tennessee appellate cases applying this, there's been something like deceit or misrepresentation or negligence. It's not been applied. This independent tort exception has not been applied in a tortious interference case. To succeed against result, he has to show there was this independent tort. But as part of this case, HCTEC first has to prove that Crawford breached the contract. It is an element of the claim. Result had to offer Crawford a job, and Crawford had to accept the job offer and start work. Because they had to act jointly, it cannot be independent. To determine to show how they're intertwined, I mean, HCTEC in this case sued both Crawford and Result. It sued Crawford for injunctive relief to prevent future breaches, and it sued Result for injunctive relief to prevent continuing to induce the breach. But HCTEC could have sued just one. The injunctive relief would have then extended to the other. Either way, Crawford's employment would have been barred. So the claims aren't independent. When you analyze these claims and you look at the case on which the trial court and HCTEC relied, that's the Edwards Moving and Rigging versus Lack case out of Western District, Tennessee, it doesn't apply. And it's quite frankly, it's bad law. In Edwards, the plaintiff wasn't seeking attorney's fees for proceeding against the new employer, their Barnhart. It was seeking about $25,000 only for the relief against the former employee. Second, Barnhart did not argue that the independent tort exception to the American rule cannot apply to claims for tortious interference with contract. The fees came up on a subsequent briefing. They're in the docket 86 and 87 of the federal court docket. But the trial court there decided for the first time that these attorney's fees in that litigation could be covered as an independent tort, something that the parties hadn't discussed in depth. And because there was relatively a small amount at issue, I mean, trebled, it was $75,000. There was no appeal to the Sixth Circuit to correct the trial court's error. But we submit that Edwards Moving and Rigging is also out of line with Tennessee policy, because the fees being sought are those fees that HCTEC is incurring in this very litigation. Indeed, it even goes so far as to ask this court to treble the appellate fees, even though the injunction for which the relief was, the fees were awarded, has since expired. This gives an incentive to continue to litigate, gambling on a windfall on the return, and potentially forcing Result and Crawford from continuing to assert their rights. And this is precisely what the American rule bars. Every dollar spent becomes $4 during the litigation if the defendant has to pay its attorney's fees and 3 times the other side's. No one could continue to defend themselves and would have to capitulate to avoid the potentially crippling burden of litigation costs under the circumstances. And this is particularly troubling here, where the compensatory damages are 0. 0 times 3 is still 0. But if you start putting attorney's fees into the mix, employers like HCTEC will continue to try to enforce otherwise unenforceable agreements because the trebling goes only one way. Result will not be able to recover its attorney's fees if this case was reversed, and certainly not trebled. But Result is being exposed to treble attorney's fees solely for attempting to defend itself. Had the General Assembly wanted to allow recovery of treble attorney's fees, like it does in other statutes, it could have written it into the statute. Turning to, and now just one point on that too, is when you look at this, the only type of damages that have been awarded under the statute have been for lost profits. And under Restatement Second of Tort 774A, which the Tennessee Supreme Court adopted in the Dorset Carpet case, it doesn't mention attorney's fees or trebling attorney's fees as the damages. Also troubling to us when it comes to this attorney's fees issue is for this statutory inducement claim is that the chancellor took two elements of the claim from the jury, intent and malice. And in Buddy Lee Attractions versus William Morris Agency, this court ruled that culpability determinations under 4750-109 are for the jury under instruction from the court. I found no decision from an appellate court in which ruled that a 4750-109 violation can be found as a matter of law. I found the reverse, right, where you can, as a matter of law, you can find that there's not a violation, but never that there's been a violation as a matter of law. Here, to Result's point, It didn't believe that the positions were in a way that they would unfairly injure HCTEC. And that's the question, right? Is it unfair competition? The trial court didn't cite at all to John Carrico's affidavit, which was submitted in support of our summary judgment. In fact, instead, it sort of took the position on HCTEC's side at every turn. And because HCTEC had the burden of proof at trial, that he needed to be taking those inferences in favor of Result and in favor of Mr. Crawford. But Result had a good faith belief that the agreement wasn't enforceable, and it had the right to get to a jury to make that determination. But if the chancellor is right, an intent and malice can be established by the mere fact that a new employer offers a potential employee a new position for more money, the statute becomes one of strict liability. This is particular concern because of its profound effect. If either intent or malice can be met by offering somebody a new job, then it's always going to be met in employee mobility cases. That is going to have an effect on the Tennessee marketplace because employers will always have to assume that they are enforceable. And if attorney's fees can always be trebled when they're in from the contract, then employers simply refuse to hire somebody who has a non-compete agreement, regardless of reasonableness. And even if there are going to be no actual damages, it turns every non-compete agreement into an enforceable agreement by fiat. We submit that the more reasonable rules that contractually allocated parties' fees are not compensatory damages, and that intent and malice must be submitted to a jury and cannot be found solely because an employer offered the employee a job.
All right. Thank you, Ms. Berg. We'll now hear from Mr. Johnson.
Thank you, Your Honor. Good afternoon. David Johnson for the appellee HCTEC. And I will start with the judgment entered against Result with the treble attorney's fees. And the argument that Ms. Berg made, frankly, we believe is better suited to be made up the hill on Capitol Hill to the legislature. The legislature was quite clear through the enactment of TCA 47-50-109 that treble damages are mandatory. And it's clear on its face about inducement. There's not even a mention in there about malice in the statute. And Result argues that there are factual disputes about the intent and malice elements. But what evidence did Result present that could create a genuine issue of material fact concerning either one of those elements? If we first take intent, all HCTEC needed to do was show that Result intended for Crawford to accept a position with Result in breach of the non-compete agreement. Result presented no evidence that that was not its intent. In fact, its corporate representative admitted that, number one, it offered him a job to lead its HIT team. Number two, it even sweetened the pot to encourage him to accept the offer. And number three, it even offered to pay him his attorney's fees if he got sued. So he had nothing to lose. As for the
Mr.
malice,
Johnson, when did the defendant Result, when did they learn of the non-compete agreement, and when did they read it?
yes, sir. So the answer to that is they knew before the time of hire that a non-compete agreement existed, but they did not ask for it. After he accepted the offer and he told HCTEC that he was going to join Result, HCTEC sent him on notice to make sure he was aware of these restrictions at that point in time while he was still working for HCTEC. But after he had accepted the offer, he provided a copy of that agreement to Result.
Thank you.
Sure. And you know, as for the malice element, again, that's not in the statute, but all HCTEC needed to show was that Result acted to violate a known right. Result does not deny knowing that Crawford was subject to the non-compete agreement. That's the only way it could escape a finding of the malice element under this court's case law is if it came forward with evidence of justification. And at no point in this litigation has Result attempted to argue any justification for its actions. For instance, one example of a justification perhaps would be that it relied upon advice of counsel. It has not asserted that defense, and in fact said it was not relying upon that. The only attempt to make any showing about malice, that they did not act with malice, is the statement by John Carrico that, well, we didn't think what we were doing was wrong. Well, that simply does not cut it. And the Edwards moving versus lack decision that Ms. Berg referred to is in fact squarely on point. The ruling was made in favor of the plaintiff at the summary judgment stage. And in fact, unlike that case, we have more facts that show malice in this case by virtue of the fact that Result required Mr. Crawford to sign a non-compete agreement when he came aboard Result as a condition of his hire. So at the same time, Result was asking Mr. Crawford to ignore his non-compete obligations to HCTEC, it was requiring and demanding that he honor a non-compete obligation to Result. And that, to me, is compelling evidence of malice. And as it relates to the issue of damages, again, the Edwards moving case is directly on point in demonstrating that HCTEC is entitled to recoup its attorney's fees under the independent tort exception that was first recognized by the Tennessee Supreme Court in the Pullman case. And the defendants have cited no case that indicates that the independent tort exception applies to certain torts but not others. In fact, it applies across the board to any tort. This was a tort. Inducement of breach is a tort. And HCTEC is not a prevailing party attorney's fee situation. HCTEC is not seeking to recoup its attorney's fees related to recovering relief against Result. It's seeking to recover its attorney's fees related to enforcement of its rights, its contractual rights, and pursuing the injunctive relief and its claims against Mr. Crawford. And those fees are subject to mandatory trebling under TCA 47-50-109. Again, Ms. Berg talks about incentives are created this way or that way. Well, that's an argument for the legislature. It was the legislature's decision to enact this statute. So what we have here is a situation in which Mr. Crawford took a calculated risk to leave one high-paying job to accept an even higher-paying job with a competitor in direct violation of his non-compete agreement. And summary judgment in this case was appropriate based upon the defendant's own deposition testimony. And I want to mention the marked dichotomy between what the defendants testified in this case versus what their counsel has argued in court filings. And by way of example, perfect example is on page 7 of the defendant's reply brief in this case. They argue that customer lists are not confidential, they're not protectable. They say it 2 more times on page 10 of the reply. But when I deposed Mr. Crawford, he unequivocally admitted that HCTEC's customer lists are confidential. And then when I deposed Result's corporate rep, he testified that Result considers its client list to be confidential. And in fact, in 2 different lawsuits that were filed in Davidson County, Result explicitly argued that its customer lists are confidential, protectable information. So in other words, Result's argument is the polar opposite of what its corporate rep testified to and what it recently argued in 2 other lawsuits. Also on page 7 of the reply brief, they say that financial information such as profit and loss statements do not constitute confidential information. Again, aside from the fact that there's no legal authority that supports that was cited, Mr. Crawford admitted that HCTEC's financial information is confidential, that he was privy to it. Result testified that it considers its financial information to be confidential. And Result has argued in other litigation, in non-compete litigation, that its financial information is confidential. So how is it that a client list and financial information are confidential if it's Result's information, but if it's HCTEC's information, then it's not? The defendants have not explained that, and I could keep going on with other examples, but I will not do so. Mr. Crawford's own deposition testimony in and of itself demonstrates that he had intimate access to a wide variety of HCTEC's confidential information. His resume, which I always think is a great tool to give a true story about what a individual's job responsibilities are. It demonstrates the key role he played with the company. Just as Result considers its unique way of doing business to be proprietary, HCTEC considers its unique way of doing business to be proprietary. So on the face of this undisputed evidence about his access to confidential information, what we saw was the defendants pivoting to arguing that, well, HCTEC won't be harmed. It wouldn't be harmed because Crawford wouldn't share that confidential information with Result. And they even claimed that despite the fact that he worked there for 7 years, that somehow the moment he walked out the door, he would somehow forget almost everything that he had learned while working for the company. But the discovery process in this case revealed some evidence that was quite damning to the defendants and their position about this. And in particular, before Mr. Crawford even had his first interview with Result, he had blabbed confidential information about HCTEC's finances and placement goals to Result's headhunter. And that's in an email that's Exhibit 29 to Mr. Crawford's deposition. From the very outset of this case, we have asserted that there was an inherent danger of Mr. Crawford sharing HCTEC's confidential information with Result and performing his role with Result. Even if he was doing it subconsciously, even if he had no invidious intent, there was an inherent risk of that. And this email, in and of itself, validates that all of HCTEC's concerns were not just theoretical, but instead genuine. So the fact that he was privy to a wealth of confidential information in and of itself demonstrated a protectable business interest to support the non-compete. In addition, I'll just finally talk about the fact that he received specialized training. The defendants have claimed that training is only protectable if it's specialized to the employer's business. That simply is not what the law provides. Instead, this court's decision in the Vantage Tech case is directly addresses that point. And the court quote said that the skill acquired as a result of that training is sufficiently special as to make a competing use of it by the employee unfair, end quote, and that makes it protectable. But in this case, we presented undisputed proof that Mr. Crawford was provided a wide variety of training that was specialized to the staffing industry in general, specialized to the HIT staffing industry, which is a subset of that, and also to HCTEC's own business. That is precisely why Result wanted to hire him as its HIT staffing director. Result had other job openings it could have hired him for, but no, it wanted him to lead its HIT group team. And the reason it did was because it didn't have to train him. Mr. Carrico testified, Result's corporate rep testified that the training he received from others was a valuable tool and asset that he had. So that it's perfectly fair under those circumstances for Mr. Crawford to be expected to honor a 1-year restriction, preventing him from taking that training and that experience and utilizing it for the benefit of a direct competitor. So for all these reasons, the appellee respectfully requests this court affirm the judgment in all respects. Thank you.
Mr. Jacob,
Yes.
Mr. Johnson, how were the treble damages determined?
Yes, Your Honor. Good question. So they were based, what we did was we took our attorney's fees and we allocated those to, we didn't seek to recoup all the attorney's fees. We only sought to recoup our attorney's fees to the extent that they were attributable to seeking the relief and obtaining the injunctive relief and protecting the rights against Mr. Crawford. Okay, so they were the invoices, attorney's fees invoices were provided to opposing counsel, and we ended up coming up with a stipulation about what that amount would be, subject to their right to appeal the issuing of the damages, but not the itemization, if that makes sense.
Well, what attorney's fees were not considered?
Good questions. So an example would be the spirited argument that Ms. Berg and I have had about whether the attorney's fees in and of themselves are recoverable. That I have not spent money, my client has not spent money getting us to research the recoverability of that to protect their right to injunctive relief.
Okay.
So those fees we don't claim to be compensable.
All right. Thank you
Yes.
for explaining that. Okay.
Thank you.
All right. Nothing further, Mr. Johnson? Okay. Ms. Berg, your rebuttal.
Thank you, Your Honor. And I will say that I disagree with Mr. Johnson because he did ask this court to treble the attorney's fees for this argument. And so to that extent, he has asked the court to treble attorney's fees for every aspect of the case. With respect to justification, which was a point that Mr. Johnson made, justification is not an affirmative defense that result needs to prove. It's actually an element of proof that they have to carry the burden of proof on. It's one of the elements of malice that they have to show. They have to show that the conduct was intentional and without legal justification, and that if it's without justification, if it's done for the indirect purpose of injuring the plaintiff or benefiting the defendant at plaintiff's expense. That's your Bobbinage versus Capital Bank case, 2018 Westlaw 3203100. So it's not our obligation to show justification as you might and as an affirmative defense. So I just want to make sure that's clear. With respect to what result does in other cases, an argument it makes in other cases, that has no bearing here. I think that is, from an evidentiary matter, is irrelevant because it doesn't assist HCTEC in carrying its burden of proof. HCTEC has the burden of proof of showing that its client list is confidential. It has the burden of proof showing that it's been damaged. To accept Mr. Johnson's argument here, you would then be saying that every staffing company's client list is confidential as a matter of law, relieving them of the burden of proof and relieving them from the elements that they're supposed to prove under the right medical tech case, right? Those are the 6 elements that they need to show. And that's what the trial court did here. It relieved him of that obligation and that responsibility to carry that burden of proof. At the deposition that Mr. Johnson referred to, he conflated confidential and proprietary. We had to lodge a standing objection that he was using terms that don't qualify under the statute. And that created a very muddled record, but it was the reason why the case needed to go to a jury. A jury needed to be able to decide whether that testimony really qualified, whether that was an admission. To the extent that that result may have a customer list and it may think it's confidential, that's certainly not admissible against Mr. Crawford in his claim for breach of contract. There's nothing there that would allow those things to cross borders. And that's exactly what happened on this summary judgment argument. And that's what made it so particularly difficult was Mr. Johnson created a muddled record on the deposition. The judge then took that, in fact, in 36 different places, pulled out things, making credibility determinations. What we're seeking here in the underlying breach of contract case is that it needed to go to a jury to decide those disputed issues of material fact. That also needed to go to a jury because it's an element of the claim against result. So even though they got the injunctive relief, to get there, you have to prove all 7 elements. And that's what the trial court relieved HCTEC from having to do in this case. And with respect to, arguments that could have been made or should have been made in another case, we made evidentiary objections in this case, multiple evidentiary objections that the trial court never ruled on. And it's those evidentiary objections that would keep the type of evidence out of the record from being considered on summary judgment. And unfortunately, the trial court either implicitly overruled them or failed to address them. But in either way, we were not given the opportunity to have a full explanation of the record or to have a jury hear the facts and to judge the credibility of the witnesses.
All right. Thank you, Ms. Berg and Mr. Johnson. You've given us a lot to think about. We'll take the matter under advisement. Mr. Hibner.
This honorable court is now in recess until 3 p.m.
Thank you. And counsel, you're free to exit the meeting.
Thank you.
Well, Judge